Okay, so I guess we can start. So by introduction, we are of course Parker Faustino Pagayatan Law Offices. My name is Jeff David, all right? I'm a junior partner at the firm. So just a guide lang po, no? The manner of how we will be conducting this webinar would be in Tagalog. Para po dun sa mga para po mas madali natin maintindihan ang mga ituturo namin ngayong hapon. Katulad po na sinabi ko kanina, ang mga panelists po natin ay of course ang name partner namin na si Atty. Oliver Faustino at ang napakagaling naming CPA, si Ms. Myra Dabalos. So sila po ang tutulong sa akin ngayong hapon upang mabigyan linaw ang mga alinlangan pa ho, no? Kasi naiintindihan ho namin na medyo technical po itong topic. So as a guide po, gusto rin ho namin maliwanagan kayo. So sa panahon pong ito, nandyan po silang dalawa. Kasi po ako, ang focus ko po ngayong hapon is maihatid sa inyo ang informasyon. Baka hindi ko ho mapansin kung meron ho kayong mga katanungan, sila ho ang pwede niyong ma-bring yung attention nila. You can get their attention and then they'll be the ones to address your questions. Pero katulad nga ho na sinabi ko kanina, mas maganda ho kung ang katanungan na ito ay ma-reserve natin until end ng webinar para dire-diretso ho tayo. Hindi rin ho namin gusto na magtagalan kayo dito. Sige ho. So, ito ho, i-focus lang po sa dalawang type of revenue issuances ng BIR, no? So, one is of course revenue regulations, ang tawag natin doon. So, yung RR. So, ito yung mga revenue regulations na kailangan na pipirmahan ng Secretary of Finance, no? Ito, of course, nire-recommend yan ng Commissioner of Internal Revenue since they are the bureau that would draft the actual rules. Pero hindi po ito na-issue kung walang pirma na Secretary of Finance, no? At ang purpose nito is of course to prescribe or define rules and regulations for the effective enforcement of the provisions of the National Internal Revenue Code and related statutes. So ibig sabihin ho ito po yung parang implementing rules natin doon. Okay? At ang pangalawa kong top kind ng revenue issuance na i-discuss natin ngayon, ito ho ang Revenue Memorandum Circular. Okay? So ito ho yung mga issuances na pinapublish, yung mga pertinent and applicable portions, as well as amplifications of laws, rules, regulations, and precedents issued by the BIR and other agencies and offices. So sinasabi ho dito, pinapakita po dito, hina-highlight ho dito yung mga importanteng provision doon sa ating mga revenue regulations, sa ating batas. At ito ho ay sinasabi at pinapakita para maliwanagan ang mga empleyado ng Bureau of Internal Revenue din ho. Okay? So, ang una-una ho nating topic ngayong hapon ay ang tinatawag nating taxpayer registration. Importante ho ito kasi matatandaan ho natin na kailangan ho natin tax identification number. Ito po yung pinakauna. Ito po yung mga updates noon. No? Hindi ho natin sinasabi na ngayon lang ho nagsimula ang taxpayer registration. Matagal na po yan at kailangan nyo pong magrehistro as a taxpayer. But in this case po, kailangan ho nating i-update yung kaalaman natin sa mga bagay-bagay. Especially po sa importanteng matter na katulad nito. Okay, so ano ho ba yung mga i-discuss natin sa topic na ito? Meron ho tayong tinatawag na Revenue Regulations number 1-2020, no? So ina-amend po nito yung revenue regulation, isang naunang revenue regulation na 11-2018. Yung pangalawa naman ho is Revenue Memorandum Circular number 60-2020. Ito po yung Revenue Memorandum Circular na nagsasabi na dapat ho magrehistro yung mga taong nagko-conduct ng business transactions through any form of electronic media. So, ayan po yun. So, ito po yung mga i-discuss natin ngayon. Unahan na po natin yung Revenue Regulations number 1-2020. Okay, ano po ba ito? So, sinasabi po dito, no, if an employee does not have an existing TIN, employer shall require the concerned employee to accomplish BIR Form 1902 in triplicates, 3 kopya, and submit and distribute the same as follows. So, yung 3 kopya po na iyan, ay pamimigay po natin yan sa isang, of course, RDO para malagay po sa sistema ang ating pangalan at ang ating tax identification number. Ang duplicate, si employer, kasi sila ho ang magiging withholding agent natin, At yung triplicate po sa atin kasi nandyan ho nakalagay ang iisa at pinakahuli nating tax identification number. Okay? Papakita ko ho sa inyo ang itsura ng BIR Form 1902. Okay? Ito ho ang itsura ng BIR Form 1902. So, nakikita ho natin dito yung mga requirement or yung mga information na kailangan nating ilagay sa ating application para makakuha ng tax identification number. Okay? At makikita niyo po dito sa page 2 o dun sa dorsal portion ho ng BIR Form 1902, yung documentary requirements. Nasa baba po iyan, nandyan ho. So kung kayo ho ay nagpaplano o nagbabalak na kumuha ng tax identification number, ito lang ho ang kailangan nyo i-submit. So kailangan nyo ho ng birth certificate, passport, driver's license, either and just any identification po, no, na makakapagpasabi na yun mo talaga pangalan nyo. Kailangan mo yan. Tapos, makapansin nyo po dito na kung kayo po ay kasal, no, legally married, no, kailangan nyo kong ilagay ang pangalan ng inyong asawa. Yung makita nyo po yung pangalan ng asawa nyo dito. Ilalagay po natin yan, spouse's name dito po. At required din po kayo magbigay ng marriage contract kung kayo po ay kasal. Ano po yung isa pang importanteng portion natin dito? Ang tinatawag natin for foreign employees, no? Alien employees. Medyo naun-ano po ito eh. Medyo hindi po ito na-update pa tong form na ito kasi sinasabi po dito na requirement po para makapag-apply ng tax identification number ang isang foreign employee ay yung AEP niya, yung at natawag natin alien employment permit. Ngayon po, dahil sa kasagsagan, no, sa kadamihan po ng empleyado ng offshore gaming operators, ni-reverse po nila yan para ma-avoid po natin yung instance na hindi makapagbayad ng nararapat na buwis ang mga empleyado nila. So, nire-require po ngayon, initially, for alien employees, bago po makakuha ng AEP, is dapat makapag-secure po ng tax identification number. Yan po. So, yan po yung unang-unang requirement for alien employment permit po. Hindi po kayo makakakuha ng AEP kung wala po kayong tax identification number. Meron pong tinatawag dyan yung parang joint memorandum circular na in-issue ang Bureau of Internal Revenue, Bureau of Immigration, and the Department of Labor and Employment to address po yung concerns related doon sa offshore gaming industry. But nevertheless, we should presume that this would apply to ordinary applications din ho for your alien employees. So if you're a company that duly employs alien foreigners, no, please take in consideration po ang requirement na kailangan mag-secure muna ng tax identification number bago po mag-apply ng alien employment permit. Okay. Bakit po ba natin kailangan kumuha ng TIN? No? As a form of review lang po, no, for those who are not familiar with the requirement. Sabi po natin, hindi naman po ngayon lang tayo nagsimula para makakuha na ang requirement ng tax identification number. So tayo po ay required kumuha ng tax identification number because Section 236 of the tax code. No? So any person, whether natural or juridical, is required under the authority of the Internal Revenue Code to make, render, or file a return, statement, or other documents shall be supplied with or assigned a tax identification number to be indicated in the return, statement, or document to be filed with the Bureau of Internal Revenue for its proper identification for tax purposes. So yun po ang batas, no, na nagsasabi kung bakit po kailangan natin kumuha ng tax identification number. Kung tayo po ay magkakaroon ng transaksyon na nagsasabi na tayo ay kailangan mag-file ng return, mag-file tayo ng statement or documents, especially with relation to the Bureau of Internal Revenue. Okay? At ang importante po nating malaman, no? Okay? Importante po nating malaman, iisang tax identification number lang po ang dapat na meron tayo. Anyone who is in possession of more than one tax identification number can be held criminally liable. Okay? Under Section 275 of the tax code. So, kung kayo po, sa tingin nyo ay meron ho kayong sobra sa isang tax identification number, pwede nyo ho ito ipacheck. No? Hindi naman ho agad-agad yan na-arrestuhin kayo. Hindi po ganoon. Pero sinasabi lang ho dito, if you knowingly violated, no, yung provision na ito, so kung kayo po, kasi nangyayari to usually pag bata pa kayo, kinuha kayo ng tax identification number ng magulang nyo for purposes of, let's say, donating property to you. Tapos nung ikaw ay naging tao na, nag-apply ka na sa trabaho, kumuha ka ng TIN ulit, yun po usually yung instance na iyan. Ganyan po yan. So kung kayo po ay sa tingin nyo ay may more than isang TIN kayo, pwede nyo po ito ipa-check, no? At pwede kayo mag-proceed to cancel yung other TINs na hindi nyo po ginagamit. Okay. Dito naman po tayo sa Revenue Memorandum Circular number 60-2020. Ano po ba ito? So sinasabi po dito sa RMC na ito, if you are in fact a businessman or a person who intends to or is currently engaging in business through any forms of electronic media. So hindi po natin sinasabi dito na ngayon lang ho kayo required magbayad. Sinasabi lang po dito is pinapaalala po na dahil kayo nagnenegosyo, kailangan nyo hong magbayad ng tax. So ngayon lang ho siya talaga nabigyan ng focus kasi because of the ECQ, alam po natin na marami tayong mga kababayan na nag-engage in online selling. Kaya po ito nabigyan ng importansya. Hindi po natin sinasabi na sila ay dapat hindi nataksan, no? Hindi po. Kasi subject po yan sa internal revenue taxes, yung negosyo po nila na yan. Sinasabi lang ng gobyerno, naiintindihan namin na kung kayo ba hindi pa nakakapag-rehistro, mag-rehistro kayo. Kasi kailangan po natin ma-capture kung ano talaga yung kailangan na bayaran na buwis ng mga taong nagnenegosyo. Ito ho ang guidelines natin dito. So pag tinignan nyo po itong table na nandyan sa screen nyo, makikita nyo po dyan na kung individual ka, kailangan mo ng BIR Form 1901. Tandaan nyo po, katulad ng pinakita natin kanina, pag ikaw ay employee, no, 1902, BIR Form 1902 gagamitin mo. Pero dahil kayo po ay dito, hindi lang kayo empleyado, magne-negosyo na po kayo, mag-a-apply po kayo ng hindi naman po panibagong TIN, i-update nyo po ang inyong registration. So mag-submit po kayo ng BIR Form 1901. So magbabayad din po kayo ng registration fee which is 500 pesos. Bibigyan po kayo ng tinatawag nating Certificate of Registration ng BIR. So ngayon po, mas maganda na po ang COR ngayon ng BIR kasi naka-indicate na po doon lahat ng tax types at kung kailan nyo kailangan bayaran yung deadlines nyo doon sa COR na iyon. Pag hindi po kasi kayo makapag-file ng returns na iyon on the specific deadline ng date, meron tayong tinatawag na non-filing charges, no? So may administrative penalties po kayo. Okay. Pag kayo naman po ay non-individual, ano po ba ang non-individual? So ito po yung mga partnership. So kung kayo po ay incorporated, nag-register po kayo ng partnership sa SEC, kung kayo po ay nag-incorporate ng kumpanya, ito po ang inyong dito po kayo magpo-fall under, no? So you have to secure BIR Form 1903. So yun po yung gagamitin yung form in order for you to be able to register your business. So kailangan nyo nga, sabi ko nga, kailangan nyo ng Certificate of Incorporation, Certificate of Recording or License to do Business in the Philippines, Articles of Incorporation, Articles of Partnership, kailangan po iyan. Same din po, registration fee, 500 pesos, i-issuean din po kayo na COR. No? Bakit po ba kailangan mag-rehistro? No? Kasi importante po ito katulad na sinabi natin sa unang discussion natin. Kasi po may requirement po talaga ang BIR na magbayad ng buwis. So kung kayo po ay hindi nagbabayad ng buwis, yun po ang problema ng BIR ngayon. Pero nevertheless, okay, that's for another day po. No? Pero ito po importante, if you are engaged in business, it is safe to assume that you are required to register your business for purposes of taxation. So under Section 236 of the Tax Code po, no? So every person is subject to an internal revenue tax shall register once. Importante po yung word na once, kasi sabi po natin, bawal po ang multiple things. Shall register once with the appropriate revenue district officer. So kung kayo po ay empleyado, you are required to register within 10 days of employment. Or on or before the commencement of business. Of course, before the payment of any tax due, okay, upon filing of a return statement or declaration as required in this code. Okay? So, under Section 236 din po, makikita nyo doon na actual provision na nagsasabi na kung kayo po ay may head office, branch, or facility, so let's say, 4 yung opisina nyo, iba-ibang syudad, no? A person maintaining a head office, branch, or facility shall register with the RDO having jurisdiction over the head office, branch, or facility. Okay? So, importante din po yan na malaman natin na hindi porket nakarehistro ang head office mo, hindi ka na magre-rehistro. Ganoon din ho ang rules for in terms of sale through electronic media. So, we follow the same law, which is the tax code, notwithstanding po yung pagbaba nito, no, maging mas specific ang RMC sa electronic media. Ganun din po. So if you are engaged in online business and you have a branch or a facility in another revenue district, no, in a city covered by another revenue district, kailangan nyo rin ho i-rehistro yun doon. Okay? So yun po. So kung kayo naman ho ay walang TIN, so susundin niyo ho itong requirements dito. Kung kayo po ay empleyado na, mag-a-apply po kayo ng update sa registration nyo. Kasi hindi na ho kayo solely compensation income earner. Magkakaroon na rin ho kayo ng ibang tax types, no? So hindi na po substituted filing pala ang gagawin sa inyo. Magpo-file na po kayo na sarili niyong tax return. So importante po yan na malaman ng mga empleyado na currently nawi-withholdan kayo ng tax, oo, nagbabayad kayo. Pero kung kayo yung nagdinegosyo, kailangan nyo pa rin hong mag-rehistro sa sarili nyo. Update nyo po yung rehistro nyo sa BIR. Pagkatapos po niyan, hindi na po kayo pwedeng substituted filing kasi po magbabayad na po kayo ng sarili nyong income tax. Okay. So, dito naman ho tayo sa regulations on tax exemptions and benefits. So, ito po yung mga i-discuss natin ngayon. So, in terms of Revenue Regulations number 2-2020, ito po yung regulations na nag-i-implement ng tax exempt provisions on the new Central Bank Act. Naiintindihan ho namin, no, na meron po kasi dito mga certain regulations or issuances na hindi nag-a-apply sa inyo specifically. But in this case po, let's just take time to discuss them. Considering po na baka may matulungan po tayo na kababayan natin in terms of their questions. So in terms of Revenue Regulations number 4-2020, no, it is a regulation implementing the provisions of RA 11256, otherwise known as an act to strengthen the country's gross international reserves, amending for the purpose sections 3 and 151 of the NIRC. So same goes din po, medyo macro yung outlook po ng revenue regulation na ito. Kung kayo naman ho ay parang small scale miner or gold trader, mag-a-apply po sa inyo itong revenue regulations na ito. Okay, so Revenue Regulations number 6-2020 naman ho. Ito yung regulation implementing the tax exempt provision of the Bayanihan to Heal as One Act. So meron po kasi tayong pinasa na batas ng ECQ para matulungan yung mga kababayan natin na naapektuhan ng COVID-19. So doon po sa loob ng provisions ng batas na iyon, meron pong mga tax exempt provisions doon. So sinasabi natin na kung ikaw ay mag-comply sa requirements ng batas na ito, specifically yung provisions ng batas na iyon, pwede kang makapag-avail ng tax incentives. Okay? I-discuss po natin yan. So yung Revenue Regulations number 8-2020, same lang din po. It implemented a certain provision of the Bayanihan to Heal as One Act. And Revenue Regulations number 9-2020 din po, same provision, same law. It's implementing the Bayanihan to Heal as One Act, pero different tax type na po tayo. Okay, so mag-start po tayo sa Revenue Regulation number 2-2020. So, sinasabi ho natin kanina, sabi ko nga ho, kung sa inyo ho, mukhang hindi ho nag-a-apply ito. Pero ini-explain na ho dito na Revenue Regulation na ito, na nung napasa yung batas, no, na yung New Central Bank Act, may pinibigay po kasi tayong parang benefit dun sa Bangko Sentral ng Pilipinas. So kung ang Bangko Sentral ng Pilipinas ay nag-i-implement ng ay kumukuha ng income, no? From its mandate to supervise the banks and the maintenance of price and peso stability. So kung may income man sila po nakukuha doon, hindi po yan subject to any national internal revenue tax. Exempt po sila doon. So kasi meron din naman po kasi tinatawag na tawag dito ay parang mandate ang BSP, no? In terms of the service it performs to help yung macroeconomic policies ng government. Pero kung meron po silang business, no, na hindi nagpo-fall under this definition ng dalawa na yan, which is income from activities involving supervision of banks and other financial institutions, and income in pursuit of its primary objective, which is maintenance of price and peso stability, subject na po yan sa internal revenue taxes. Yun lang po ang parang summary nitong revenue regulations na ito. Importante po yan kasi nadidelineate na po ang powers ng Bangko Sentral ng Pilipinas. So yung proprietary business nila na kumikita sila sa negosyo nila, meron na hong tax iyon. Pero kung ang trabaho nila is in furtherance of yung policies ng government or in performance of its mandate, no? Hindi po taxable iyon. Yan lang po yung ibig sabihin nitong Revenue Regulations number 2-2020. So, ito naman po, ang Revenue Regulations number 4-2020. Kasi tandaan po natin na meron po tayong reserves, international reserves, one of which is, of course, gold. So, ginagamit po natin yan. So, in order for them to bolster yung pagbenta ng ginto sa BSP, binibigyan po nila ng tax incentives ang small miners, no? Yung mga maliliit na nagmimina ng ginto. So ano po ba yung importante dito? So makikita niyo po dito sa inyong screen yung definitions natin, no? Ng dalawang klase. Sila po kasi yung mga entities na pwede mag-avail ng tax incentive na ito. So you have accredited traders, yung persons, entities engaged in the business of buying and selling gold. All right? And of course, which is very important po, no? Itong have complied with the BSP's gold trader accreditation procedures. So meron po yan parang certification that will be issued to you by the BSP that you are in fact an accredited gold trader. Hence, you would be able to avail of the tax exempt provisions of this regulation and the law. So pag kayo naman ho ay registered small-scale miner, importante ho ito a Filipino citizen who have organized themselves as an individual miner or cooperative. In fact, you're duly licensed by the Mines and Geosciences Bureau. So, ang intention ho ng cooperative nyo dapat is to engage in the extraction of minerals or ore-bearing materials from the grounds under the terms of a small-scale mining contract. So, ayan po yung inaano natin dito na strengthening countries' gross international reserves. So, sabi po dito, kung kayo ay nagpo-fall under sa definitions itong dalawa, either you're a small-scale miner or a trader, pwede po kayong mag-avail ng tax incentives, no? In order for you to be able to secure the tax incentives, importante kong malaman natin na ang pinaka-importanting requirement po dito, aside from the certification from the BSP, is that meron po kayong tax identification number. So meron po yan. So also yung ikaw ay registered small scale miner, meron din yung certification dapat na makuha from the BSP. Okay? So although sabihin ho natin na meron po kayong kayo ay sinasabi niyo sa sarili niyo, ako ay registered small scale miner, magko-comply ako sa requirements. This does not preclude, no? Hindi ho pinagbabawalan ang BIR na mag-audit at mag-assess at i-check kung kayo ho ba ay entitled sa tax incentive. Sinasabi po natin yan. Hindi po nawawala ng karapatan ng BIR, kahit sabihin mo natin sa sarili natin na tayo ay registered small-scale miner, the BIR can go into the determination of whether or not you fall within the requirements or the definition of the tax incentive, no? So kung kayo po ay napag-alaman ng BIR na hindi po kayo nagpo-fall within the definition, kayo po ay magiging primarily and solely liable for any deficiency taxes. So kayo po, let's say, magbabayad po kayo ng withholding tax and income tax dito. magbabayad ho kayo. Kung kayo po ay nagsabi na registered small scale miner ka, nag-a-avail ka ng tax incentive, yun pala hindi ka pala pwedeng mag-avail ng tax incentive dahil hindi mo na-fulfill yung requirements dito, bayad ka. Hindi mo ma-avail ng tax incentive. So, importante po yan. May definitions po ang revenue regulations. Kung gusto niyo po ma-avail ng tax incentives, you have to be able to fall within a definition and the requirements as stated. Strict po yan, sirs and ma'ams, no? Importante po yan. So, dito na po tayo sa Bayanihan to Heal as One Act, no? RA 11469. Alam po natin nung kasagsagan nung sa simula po ng ating COVID-19, no, nung pandemic, medyo nahirapan ho ang gobyerno. Medyo nahirapan po ang gobyerno in terms of parang kung paano natin i-kontrolin yung pandemic. Marami hong nagsabi sa atin na hindi tayo prepared. In one way po, this is the response of the government, no, to ensure that we would have enough supply of medicine, equipment to address the pandemic. So ano po ba yung binibigay na incentive nitong Revenue Regulation number 6-2020? So pag kayo ho ay mag-i-import ng critical healthcare equipment or supplies, and these are in fact intended to combat COVID-19 public health emergency, it will be exempt from value-added tax, excise tax, and other fees, no? So, yan po yan. Ang ibig sabihin yan. Yan po ang pinaka-importanting provision nitong Revenue Regulations number 6-2020. Bakit po tayo, sinasabi po natin, bakit kailangan palagay yan? Kasi tandaan po natin, kung kayo'y nag-i-import, no, meron po tayong tinatawag na VAT on importation. So, aside from yung, if ever hindi po siya subject ng free trade agreements, no, magbabayad mo kayo ng taripa plus VAT, no? Yung VAT po, nire-remit yan sa BIR. So in this case po, ang sinasabi ng BIR, wala nang VAT on importation, no? Excise tax, wala na rin. Kung may mga administrative fees yan, wala na rin. But as long as those items that you imported fall within the definition of critical or needed healthcare equipment or supplies. Importante po yan. So ano po ba yung examples ng critical healthcare supplies natin, no? So in this case po, what are critical healthcare supplies? It includes personal protective equipment, yung PPE suits, laboratory equipment and its reagents, medical equipment and devices, support and maintenance for laboratory and medical supplies, medical equipment, surgical equipment, of course, and then yung supplies to address those equipments, tools and consumables like alcohol, sanitizers, tissue, thermometers, hand soap, detergents, very specific, no? Sodium hydrochloride, cleaning materials, providone iodine, common medicines like as provided in the revenue regulations, no? Paracetamol tablets, and of course yung suspension ng paracetamol, mefenamic acid, vitamin tablets and suspension, hyoscine tablet, and of course suspension, oral hydration solutions, cetirizine tablets, testing kits, and such other supplies or equipment as may be determined by the DOH and other relevant government agencies shall be exempt from VAT, excise tax, and other fees. So importante po iyan. Hindi naman po natin sinasabi na kung wala dyan sa listahan ng revenue regulations na iyan, hindi na siya exempt. Susundin po natin ang rule na maglalabas po ang DOH ng listahan of what other equipment or items are deemed critical in the fight against COVID-19. And we can apply the provisions of Revenue Regulations number 6 to that. So kung nakita niyo po, mag-i-import kayo, sabi mo, ay wala sa listahan dito ng Revenue Regulations number 6, yung gusto kong ipasok sa Pilipinas. I-check niyo po ang listahan ng DOH. Meron po silang tinatawag na critical equipment. So kung nag-fall po doon yung mga specific equipment types po, no? Kasi katulad ho nito, makikita niyo ho dito, very specific lang, very broad, PPE lang. Hindi na minention ko anong type ng PPE. Mask ba yan? N95 mask ba yan? Surgical mask ba yan? Wala akong ganun dyan. Kaya po natin sinasabi dito na meron pong mas specific na listing ang DOH kaysa sa binigay ng Revenue Regulations number 6. Pero hindi nagsasabi niyan na kung wala dito sa listahan na ito, hindi na siya exempt. Sundan niyo po yung listahan ng DOH at i-apply ang Revenue Regulations number 6-2020 sa listahan na iyon. Okay? So, importante lang po na ma-check natin yung compliance dito kasi hindi po natin alam kung kayo po ay dapat magbayad ng 12% VAT. Kasi it's actually a statement of you have to determine yung nature ng item na ini-import po, no? Okay? So also, if the imported articles would be donated, no? So if these would be donated to the national government or any entity created by any of its agencies to any political subdivision of government, these would be exempt under the National Internal Revenue Code. Okay. So meron po kasi tayo tinatawag na authority to release imported goods, no, under Revenue Memorandum Order number 35-2002. So importante po kasi na makakuha kayo ng ganitong dokumento. So nung ATRIG, no? So kung kayo po ay hindi nakasecure ng ATRIG, no? Pero kayo po ay nag-i-import, especially with regard to critical healthcare equipment, magkakaroon po kayo ng post-investigation or audit on the part of the BIR, no? So kasi pinapayagan po tayo ng customs ngayon na mag-import kahit walang ATRIG at ma-release tong mga imported goods na ito. So subject po kayo. So kung if you were able to take your goods out of the customs area, yung port area, and bring it to yung sa customs jurisdiction ng Philippines, magkakaroon po kayo ng post-investigation or audit on the part of the BIR. So the customs would provide the BIR with a list of importers or importations, no, that were released without the said authority. And then those importations would now be subject to a post-investigation or audit by the BIR, just to determine whether or not, in fact, they still fall within the requirement of yung value-added, the requirements of the revenue regulations, which would entail yung incentive po. So kung kayo po ay hindi pala entitled, magbabayad po kayo ng deficiency VAT, excise tax din po, the surcharge, interest po. Yan yung sinasabi natin na bakit importante yung post-investigation and audit. Okay. So, ano naman itong Revenue Regulations number 8-2020? So, natatandaan po natin dito na doon sa provision ng Bayanihan to Heal as One Act, meron pong binibigay na 30-day grace period para makapag, yung in terms of loans, no, sa mga may utang. So yung batas, nasabi niya na importante na magbigay kayo ng grace period sa inyong mga borrowers. So it was mandated by the law. So itong revenue regulation na to implements yung tax provisions po related to the 30-day grace period. Ito po ang nag-benefit po dito, no, is yung, of course, yung lender. Kasi syempre, yung restructuring ng loan, so of course, since there would be a deferment of the payment, therefore, it can be considered yung either restructuring or extension. Meron pong may kalapit na babayaran na DST dyan. So, yung documentary stamp tax. Kasi kung yung sa provision po ng batas natin, no, Section 178, so you are required to there is a levy, no, or a stamp tax on bank checks, draft certificates of deposit, not bearing interest, and other instruments. Or, of course, Section 195 then, stamp tax on mortgages, pledges, and deeds of trust, no? So, meron po yan, and stamp tax on assignments and renewals of certain instruments for Section 198. Ito po mga provisions na ito, pinapakita lang po natin dito. Sinasabi kasi natin na may tax implications po kasi yung 30-day grace period na ito in terms of the levying of, yun nga, yung sinasabi natin documentary stamp tax. So kung ang bangko po is to implement this, or is, of course, they're mandated, if they are implementing this, they can secure the benefit of yung incentive nung wala ng additional DST. So for credit extensions, restructuring, micro-lending, no? So may kita po natin dito yung covered institutions. So all lenders, including but not limited to banks, quasi-banks, non-stock saving and loans association, credit card issuers, pawn shops, other credit granting financial institutions under the supervision of the BSP, SEC, or the Cooperative Development Authority, GSIS, SSS, Pag-ibig Fund. So as I said earlier, this provision po kasi, or this regulation implemented Section 4AA of the Bayanihan to Gilas 1 Act. So since it directs yung mga covered institutions na ito, no, to implement a minimum 30-day grace period for the payment of all loans falling due within the period of the ECQ without incurring any interest, penalties, fees, or other charges. So, and it specified clearly that each and every person with multiple loans shall likewise be given the minimum 30-day grace period for every loan. So, yun po yun. Tapos may kita nyo dun sa other part ng ating table, yung mga types of loan transactions na ating pwedeng ma-avail, or sorry, na covered within the 30-day grace period pala. Okay? Right. Dito naman po tayo sa Revenue Regulations number 9-2020. Ano naman po ito? So the type of tax that you would actually be able to derive a benefit from is the donor's tax. No? If you are intending to support the efforts of government in terms of the fight against COVID-19, you would have to, pwede ka mag-donate. No? Pwede ka mag-donate ng gamit. Okay? So, nakalista po dito kung anong klaseng mga donations yung pwede nating ibigay, no? Cash donation ba ito, donations of all critical or needed healthcare equipment or supplies, relief goods, use of property whether real or personal. Okay. Tapos, sinasabi kasi natin dito, importante din po yung value-added tax treatment of donations in kind. So you have donations of critical or needed healthcare equipment and relief goods shall not be treated as a transaction deemed sale, subject to that. So kung kayo ho ay, let's say, medical supply company, no? Kung meron ho dyan nakikinig na kayo po ay medical supply company and you intend to support the efforts of government and you have in your inventory items that are in fact items for sale. So sabi nyo, idudunit ko na lang sa gobyerno ito. Kung hindi naman ho yan ordinary, let's say, donation, no? Assuming hindi siya donation, and then you intend to make use of that item, that can be considered as a transaction deemed sale, because a transaction deemed sale is use or consumption not in the course of business of goods or properties originally intended for sale or for use in the course of business. So, importante po iyan na malaman natin yan. So, kahit inventaryo mo yan, ginamit mo yung inventaryo mo, it can be considered vatable. But in this case po, the BIR is willing to waive that said rule, no? As long as that use, no, of that good is for a donation to the government, an accredited NGO, or under this provision po, under this revenue regulation, we need the requirement na accredited NGO. So any NGO po. Okay? So, but as we've already said earlier, the BIR would never give up its right to verify yung claim of tax exemption. So it's safe to say that the right of the BIR to audit or to check yung donation or yung the veracity of the exempt nature of that donation through an investigation or audit is still there. Diyan pa rin po yan. Okay. Dito po, i-explain lang natin yung difference between yung donor's tax, which donations that are already exempt under NIRC, and donations under Section 4 of the Bayanihan to Gilas 1 Act, exempted during the period of state of the national emergency. So, ang difference lang po natin dito is ganito. In the ordinary course of business, assuming na wala pong Bayanihan to Gilas 1 Act, no, you are only entitled to the donor's tax, exemption from donor's tax. If you donate to the national government or to an accredited organization. Ano po tinatawag nating accredited organization? An accredited organization is an organization. Kasi may tinatawag po tayong non-government organization. Meron po ang DOF na accrediting body ng mga NGOs na ito. So yung para ikaw ay mag-fall under dun sa tax exempt or yung makapag-avail ka ng tax exempt nature ng donation sa iyo, kailangan mong magpa-accredit. Pero sa panahon natin ngayon, meron po tayong tinatawag na non-accredited organizations na pinapayagan din kung tumanggap ng donations because of the revenue regulation. So, hindi po ito dahil sa batas, kundi dahil lang po sa issuance ng BIR. So, kahit kayo ay walang registration or accreditation galing DOF, pwede po kayong tumanggap ng donation at ang donation po na ito ay pwedeng makonsider na tax exempt. So, ano po ba yung mga non-accredited organizations? So, ito po ay mga private hospitals, non-stock, non-profit, educational and or charitable, religious, cultural, or social welfare corporation, institution, foundation, NGO, trust or philanthropic organization, and or research institution or organization. So, yan po yan. So, pwede po kayo mag-donate. Huwag po kayo matakot, no? So, kung ang dinonatan niyo po ay non-accredited NGO, pwede po pa rin yan. Papayagan po kayo ng batas, ng revenue regulation na mag-donate, and it would be exempt from donor's tax po. But you would have to comply with certain requirements in order for that donation to be considered tax exempt po. Okay. So, meron po tayong requirement, no? Documentary requirements that you would have to comply with in terms of donor's tax exemption. So first and foremost, you would have to get, of course, a deed of donation that would clearly indicate kung ano po ang dinodonate natin. Okay? Add to that is, of course, a certificate of donation, BIR form 2322, if you are going to donate to accredited organizations. Okay? Importante po ito na malaman natin ito na kung bakit po kailangan ng mga forms. Ito po yung sample form natin ng certificate of donation.
May problema, sorry.
Ayan. As you can see po, makikita niyo dyan, you have to indicate yung type of donation. So, kung personal property yan, condition, new, used, acquisition cost, depreciation, net book value, kailangan po yan. Why is it important? Kasi kailangan po natin malagyan kung magkano yung peso value ng donation na yon. Yan po yung pinaka-importanting nature ng certificate of donation. Yan po yung pinaka-importanting feature nun. Kasi kailangan po yung peso value. Kasi ang determination natin dyan is, let's say, assuming that you are not entitled to the exemption, the BIR would now levy the appropriate donor's tax plus surcharge and interest. Okay? Aside from that, okay, you would also be required to secure an acknowledgement receipt. May template po si BIR dito, so you don't have to create your own. Sorry. Okay, it seems that it's not working, no? But they have a template that you can actually describes kung ano yung information na kailangan mo i-provide, which is namely that they have received the amount, X amount of goods, equivalent to X amount in pesos. Yun po yung importante doon sa sinasabi nating acknowledgement receipt na iyon. Okay? So, you have to find out po, you have to ensure that you comply with these requirements. Hahanapin po ng BIR ito. Kasi the BIR is not precluded from auditing the actual donation. Okay? So, also, you would then be, let's say if you're the donor, you would be required to execute a sworn certification, no? So, of course, yung kanino ka nag-donate, sino yung donee mo, kailan mo dinonate yung goods na iyon. Of course, as I said, yung value. And the donation was made solely for the purpose of supporting efforts to fight COVID-19 during the period of the state of national emergency. So, importante po iyon. So, kung let's say, if you are, kasi dideduct mo yan sa, ano mo sa, ano mo to as expense, no? Sa, ano mo, sa books mo. So, lalagay mo ngayon doon kung ano magkano yung purchase price mo. So, you purchase these goods for X amount. Yan yung expense mo for purposes of donation. So, kung sabi ko nga po, kung after all these issues, no, kung magkaroon man, kung after all this matter, nag-comply ka at hindi naman pala, hindi nyo masunod yung requirements ng BIR, you would now be subject to, of course, a donor's tax, no, and then yung interest and surcharge noon. Kailangan nyo pong bayaran yan. Okay. Dito naman po tayo sa implementation of tax provisions of laws, no? So, there would be 1, 2, 3, 4 issuances that we will be discussing. So, ang isa sa mga pinakamahaba po dito is yung Revenue Regulations number 3-2020. So, it amended yung provisions nung 13-2011 nung Real Estate Investment Trust Act, no? So, yung rules implementing the Real Estate Investment Trust Act. So, also, Revenue Regulations number 13-2020. So, ito yung for national athletes and coaches. So, yung incentives na ibibigay sa kanila, nandyan na po yan. So, yung next naman po is Revenue Regulations number 19-2020, yung mandatory disclosures of related party transactions. Very important po yan, especially for those with affiliate companies, subsidiaries, etc. And RMC 59-2020, ito yung mga temporary measures na, mga temporary measures wherein the taxpayer is allowed to implement during the time of the pandemic, nung ECQ. Start po tayo sa REIT, no? Sa Revenue Regulations number 3-2020. Okay. Ang Revenue Regulations number 3-2020, no? It amended an earlier issuance of Revenue Regulation 13-2011. So it implemented, of course, yung issuance na yun, yung 13-2011, implemented yung RA 98-561, REIT Act of 2009. So, ano po ba yung Real Estate Investment Trust? If you've been reading the news, alam niyo po na ang Ayala Corporation ang unang-una na aprubahan. So, in this case, it is a stock corporation. It should be established in accordance with the Corporation Code and the rules and regulations promulgated by the Securities and Exchange Commission. So, ang principal purpose ng REIT is to own income-generating real estate assets, investment fund, or security, and that invest in income-generating real properties owned and operated by a company of shareholders who can contribute money to invest in commercial properties. Okay? So, importante po dito yung definition na stock corporation siya. Established in the accordance with the Securities and Exchange Commission, no? So, but what makes it a real estate investment trust po? So, a corporation becomes a real estate investment trust and qualified to avail of the incentives and privileges of the aforementioned law, RA 98-561. When it's real estate investment trust plan, may plan po kasi yan na kailangan i-submit sa SEC. So if that plan has been approved and its listing in the PSC has been approved by the exchange. So dalawa po iyan. So kailangan ma-approve yung plano nila and dapat makapag-list sila sa Philippine Stock Exchange, no? Kasi importante po yung listing na requirement kasi makita po natin sa sunod na slide. Okay. Kasi dito po, makikita nyo dito, yung definition ng REIT, it has to be a public company. So a public company means, ang definition po ng public company dito is ng for the benefit of the revenue regulation po. It does not mean that this is a definition of a public company in terms of in general. No, this is for purposes of implementing the tax exempt provisions of this revenue regulation. So a public company, for purposes of this regulation, means a company listed with the exchange in which upon and after listing have at least 1,000 public shareholders, each owning at least 50 shares of any class, and who in aggregate own at least 1/3 of the outstanding capital stock of the real estate investment trust. So in this case po, pag tinignan nyo dito sa kabila, yung sa Revenue Regulations 13-2011, tinanggal po yung isang requirement. No? So at least 40%. Tinanggal na po yan. Automatic 1/3 na lang. Wala nang requirement to increase to 67%. Automatic, it's defined as a public company entitled to the incentives if at least 1/3 of its capital stock is owned by 1,000 shareholders owning 50 shares each of any class. Yun po. Next po natin is other requirements which are listed in RR 3-2020 na wala dun sa earlier issuance po. No? Ang importante po dito is number 1, reinvestment plan. Wala pong ganyang provision dun sa earlier revenue regulation. So in this case po, it is to reinvest. Any investment plan refers to a sworn statement duly received by the Securities and Exchange Commission, signed by the sponsor, promoter, and principal shareholder of the REIT, firmly undertaking the following. So ito po yung mga kailangan na contained doon sa reinvestment plan. So it is to reinvest any proceeds realized by the sponsor, promoter from the sale of REIT shares or other securities issued in exchange for income-generating real estate transferred to the REIT, and any money raised by the sponsor promoter from the sale of any of its income-generating real estate to the REIT, including any redevelopment thereof, infrastructure projects as defined in RA 6975 and its relevant implementing guidelines. And importante po that the reinvestment shall be made within 1 year from the date of the receipt of proceeds or money by the sponsor or promoter. So yan po yung pinaka-importante nating requirement. Kasi wala po yan dun sa earlier na revenue regulation na ina-amend nitong i-discuss natin ngayon. So kailangan po ng reinvestment plan ng proponent, no, or nung promoter ng REIT in order for it to be considered or falling within the provisions ng revenue regulation, therefore entitled to the tax incentives. Okay. Ano po ba yung tax incentives natin? So makikita po natin dito kasi meron pong reduction on DST rates, no? So parang if you would see 0.75 tapos sabihin mo sa akin, attorney, bakit parang tumaas? Kasi practically double po ang DST rates natin with the train law. So although it looks like it's lower, in fact, lang siya, dinoble lang po yung DST kasi nagdoble po talaga yung DST rate. Effectively, it's actually 50%, no? You get a 50% deduction on any DST due if you comply with the requirements under Revenue Regulations 3-2020. Okay, so it's important that you comply kasi may DST po yung transactions, no, in setting up the REIT, and at the same time the transfer of properties. In this case, magkakaroon po kayo ng benefit. Malaki po ang masisave, especially with regard to yung valuation ng mga properties na ita-transfer. So makakatipid po tayo. Okay, so ano po ba yung general conditions, no, para ma-maintain natin yung tax incentives? So makikita natin dito, importante po na it maintains its status as a public company. That's very important. And the definition of a public company as provided under Revenue Regulations 3-2020 po. Yan po ang definition na susundin natin. So for the DST incentive on transfer of real property provided for under Section 6, enlist within an exchange within 2 years from date of initial availment of the DST incentive, and maintain the listed status of the investor securities on the exchange and the registration of the investor securities by the SEC. Okay, and then distribute at least 90% of its distributable income as required under the Act and its IRR. And of course, as part of the requirements under this revenue regulation, you comply with its reinvestment plan as certified by the Securities and Exchange Commission. Okay, a certification from the Commission that the REIT is compliant with its reinvestment plan must be submitted by, of course, the trust, as an attachment to its annual ITR and AFS on or before April 15, or yung 15th day of the 4th month following the close of the fiscal year. So on the nag-file sila, required nilang submit yung reinvestment plan. Yung certification na nakapag-comply sila sa reinvestment plan. Kasi po, as we said earlier, RR 3-2020 provides for tax incentives, but these tax incentives can only be availed of if you comply with the requirements. So in this case, importante po na yung reinvestment plan as approved by the Commission is followed through by the trust. And that reinvestment plan would be, I don't know the actual term now, if it will be audited or will be checked for compliance by the SEC, and they would certify if the trust has complied with the covenant stated in that plan. If they have, then the tax incentives would be availing. Kung hindi, you would be assessed deficiency DST, surcharge interest din po, as provided for in the next slide. Okay. So, important din po kasi kino-consider natin na if the sale or transfer, kasi you have to understand kung ano po ba yung REIT. Of course, a REIT does not own the property outright. Hindi po siya yung kumpanyang nagmamay-ari. May company po nagmamay-ari dyan at ang transfer niya po yung assets niya, yung property niya doon sa REIT. And then that transfer in the ordinary course of business, assuming that it's not a real estate investment trust, is subject to taxes. Okay? So that's why if the sale or transfer of property occurred prior to the listing of the REIT in the, of course, the exchange, the REIT, as an additional requirement, shall execute an affidavit of undertaking that it shall list within 2 years from the date of its initial availment of the incentive. So pwede ka pong mauna sa listing. Kung di kayo nakapag-list outright and yet you proceeded with the transfers of the assets already, you can execute an affidavit of undertaking na gagawin mo yung requirement ng RR 3-2020, which is to list with an exchange within 2 years. Okay? Kailangan din po natin malaman kasi na mag-transfer po kayo ng assets. And most of the companies that will be availing of this benefit, or this scheme is, or this structure is in fact real estate companies. Sabi ko nga po, a good example is Ayala Land. They availed of this already, and then the very first company in the Philippines that was issued yung REIT, so, or approved yung plan nila, sila yung unang-una. So in this case, Revenue Regulations 3-2020 does not distinguish between ordinary and capital assets for purposes of VAT if transfers are done via property for share swap under Section 40C2 of the tax code. So you can do that kasi po. So kung mag-40C2 transfer ka, you would actually be transferring your asset for shares in another corporation. So let's go by one. Himayin po natin yung sinasabi nitong provision na ito. So ano po ba muna ang capital assets? So as a form of review, capital assets shall refer to real properties held by a taxpayer, whether or not connected with his trade or business, which are not included among the real properties considered as ordinary assets under Section 39A1 of the tax code. On the other hand, ano naman po ang ordinary assets? Ordinary assets naman po shall refer to all real properties specifically excluded from the definition of capital assets. Ano po ba itong examples? Sa under nung provision ng tax code, nagbibigay po siya na example. So stock in trade, of a taxpayer or other real property of a kind, which would properly be included in the inventory of the taxpayer on hand at the close of the taxable year. Real property held by the taxpayer primarily for sale to customers in the ordinary course of his trade or business. Real property used in trade or business. Okay. Real property used in trade or business of taxpayers, or real property acquired by banks through foreclosure sales are considered as ordinary assets. So, ito pong mga nakalist na ito, makikita niyo po iyan under Section 2B of Revenue Regulation 7-2003. Okay. So, importante po yan na malaman natin dito, no? Kung ano po yung definition ng dalawa. Kasi in the ordinary course of business, if you transfer ordinary assets, usually vatable po yan. But now po with train, which will be addressed by the panelists later, they will, if you have questions on the vatability of transfers of capital assets, they would be able to address that later. But suffice it to say, wala pong hindi po nag-distinguish si RR 3-2020 whether or not the assets that we would be transferring are considered ordinary or capital in terms of vatability. Okay? So, ano po ba yung 40C2 transfer? Okay? Ang 40C2 transfer po kasi, it is found, kaya po sinatawag na 40C2 transfer because it's a transfer that is found under Section 40, subsection C, subsection 2 of the tax code. So, meron po kasing exemption, no gain or loss shall be recognized if in pursuance of a plan or merger or consolidation, no? So no gain or loss shall be recognized if property is transferred to a corporation by a person in exchange for stock or unit of participation in such a corporation of which, as a result of such exchange, said person alone or together with others, not exceeding 4 persons, gains control of said corporation, provided that stocks issued for services shall not be considered as issued in return for property. So yan po yun. Mostly po kasi pag 40C2 transfers, DST lang po ang liability. Okay? As we've said, maintenance of its public company status is very important. Failure to comply would merit yung audit, and at the same time levying of the balance of the 50% na incentive along with surcharge interest po. And it is reckoned from the time of the availment of the incentive. Hindi po yan from the time of the denial. No, from the time na sinabi sa ng BIR na, oh, you are not entitled to this incentive. Hindi po yan reckoned from that date. It's reckoned from the time that you availed of the DST incentive. So from the time that you filed the return with a 50% discount, dyan po natin i-recon yung ating 50% deficiency DST. Okay. Dito naman po tayo sa ating Revenue Regulations number 19-2020. Okay. Dito pala tayo. 13 pala muna, sorry. Okay. I skipped one provision. Apologies po. No? So in this Revenue Regulations number 13-2020, ang magkikinabang po dito are yung national athletes and coaches natin. So it implements the tax privileges granted to covered privately owned establishment, granting 20% sales discounts and incentives to national athletes and coaches. So naalala niyo po ba yung issue nung nabalita na si, I don't know if it's a particular athlete, no? Correct me if I'm wrong, pero si Gretchen Ho, pinakita niya na dapat may benefit sila na kuha nung kumain sila sa restaurant. If it's applying this specific provision, meron po tayong tinatawag na benefits na i-grant. And along with the grant of those benefits, may makukuha po kasing tax incentives yung businesses that would provide the 20% sale discount. So ito po yung tinatawag nating coverage ng Revenue Regulations number 13-2020. Pero you have to qualify po, no? Only qualified national athletes and coaches shall be entitled to 20% sales discounts on sales amount inclusive of VAT from the specified covered establishment relative to the sale of goods and services for the NAC's actual and exclusive use or enjoyment. So, ano po ba yung qualified natin na NAC. So, ang qualified na athlete and coach po, bibigyan po sila ng Philippine National Sports Team Identification Card. So, may card po yan officially. I'm not sure if they're issuing it now, no? But they should be issued with this type of card and a booklet, katulad nung sa senior citizens. So it would be issued by the chairman of the Philippine Sports Commission. So in order for them to avail of these incentives or yung benefit ng 20% sale discount, they have to be in possession of their identification card and their booklet. So alam po natin na nakalagay dito specifically na 20% sales discount on sales amount exclusive of VAT from the specified covered establishment. Ibig sabihin, hindi po ibig sabihin ito na yung vatable, yung mga enterprises lang po or establishments lang registered for VAT ang required mag-provide ng 20% sales discount. Hindi po. Even if you're not a VAT taxpayer, you are required to give the 20% sales discount. So how do we go about parang yung formula po, no? So if you are a VAT taxpayer, the VAT on the sale shall be based on the sale amount net of discount. So the rules would be the amount of sale. So yan yung inclusive of VAT, less of course yung 12% VAT. Then deduct mo yung 20% na discount. Then multiply mo ngayon yung 12% doon sa total amount na discount. Okay? So what if non-VAT taxpayer naman po? Okay, this is very important kasi it also covers non-VAT taxpayers. No? So the sales discount shall be included for purposes of computing the 3% percentage tax and shall be included as part of the gross sales receipts for income tax purposes. But the sales discount shall be counted as deduction from the gross income of the establishment for the same taxable year that the discount was granted. So hindi po siya automatic doon sa in terms of computing. So sasama mo po siya doon sa determination of 3%. Okay? Ang deduction po sa income, sa dulo na po yun. Okay. So what are the privately owned establishments and transactions that are covered, no? So under the RR, they listed domestic transportation. So that includes yung domestic transportation, national land transportation privileges, yung mga public utility buses, public utility jeepneys, taxis, TNVS, kasama po yan. Yung domestic sea and air transport po, the discount should be based on yung actual fare, including baggage allowance. Right. So hotels, resorts, and other similar lodging establishments po. Okay, so the discount should be for room accommodations and other amenities offered by the establishment. So if they have barbershops, massages, so kasama po yun. Makukuha po nila yung discount. No? So hindi lang po yung for the room, but for the amenities as well. So sa restaurants naman po, medyo hinimay-hinimay nila. Because we understand sometimes naman po that the national athlete or coach will not eat alone. So for restaurants, discount is for the purchase of food, definitely. Drinks, dessert, and other consumable items served by the establishment. Hindi po papayagan under the revenue regulation yung proxies for authorization in favor of another person. Okay? Also, it is important to note that the items purchased by the NAC shall be processed separately as an independent transaction from non-eligible companions. For those food, take-out, take-home, drive-through orders, the most expensive meal combination shall apply to the food purchases by the NAC. Kasi matandaan po natin, syempre, if you're dining in, the server or the restaurant will be able to determine which order was made by the NAC. Alin dyan sa in-order na yan, yung sa kanya. Pero kung ito ay drive-through, take-out, delivery, kung ano yung pinakamahal doon sa order na iyon, yun ang gagamitin na basis in terms of where to apply the 20% discount of the NAC. Okay. Recreation centers. The discount applies to the fees, charges, and rentals for the use of any sports facilities or equipment and other accessories and gadgets relative to the exclusive use or enjoyment of the sports and recreational activities. So in this case, may exception lang po tayo ha. Stock, non-profit, exclusive sports and country clubs po, hindi po siya kasama. Medicine and drug purchases, the discount applies to the purchase of generic or branded medicines, including vaccines, vitamins, supplements. The term medicine shall refer to both prescription and non-prescription medicines. So mga supplements kasama po dyan. As long as these articles are approved by the BFAD DOH, and these are intended for diagnosis, cure, mitigation, treatment, or prevention of disease. Okay? But specifically po, these do not include food and devices or their component parts or accessories. So yung tinatawag po nating medicine drug purchases, hindi po kasama dyan yung mga let's say nebulizer, ganun. Basta equipment po, hindi po siya kasama. So why do we say that it is important to bring always, for the NEC, I mean, for them to bring their ID and their booklet? Because of the second item, which is sports equipment purchase. Because under the revenue regulation, purchase of any sports equipment for the actual and exclusive use and enjoyment of the national athlete or coach, no? Before they would be allowed to avail of the discount, the 20%, the purchase must be endorsed by the National Sports Association, okay, of the athlete or coach, and the endorsement should be inscribed in the booklet, which would include the quantity restriction. The purchase would be recorded in the booklet as well. So hindi ka pwedeng bumili ng sobra pa sa kinakailangan mo. So ine-endorse po yan dapat ng NSA mo, ng parang parent body ng athlete, no? And of course, the purchases, even ilalagay din ho yan sa booklet. Yan yung proof na nakapagbili na ng equipment. Kasi actual and exclusive use lang po yan dapat ng athlete and coach. Okay. Yung sa theaters, cinema houses, concert halls, circuses, carnivals, and other similar places of culture, leisure, and amusement. The discount applies to the entry fees lang po. So let's say a good example, Enchanted Kingdom, Star City. All other goods and services sold by these theaters, cinema houses, concert halls, which are not included in the enumeration provided above. So hindi naman po siya housing, food, medicine, or sports equipment. Walang discount po yun. No? So even if the sale of these equipment, let's say, bili siya ng t-shirt, nakasulat doon yung name ng theater or cinema, hindi na po covered yun at 20% sales discount. Okay. So ano po ba yung tax incentives that are being granted to these establishments that would want to avail of under this revenue regulations, no? So establishment granting sales discounts to NAC shall be entitled to deduct the said sales discounts from their gross income. Okay, ito po yung requirements. Deduction should be made in the same taxable year as the discount that's granted. Name of NAC, and of course, yung booklet po, must be reflected in the record of sales. Gross selling price and sales discount must be separately indicated in the official receipt sales invoice. Makikita nyo naman po yan dun sa inyong mga invoice requirements. Meron po mga breakdown requirements po yun sa gilid. It's either on the left side no resibo. Allowable as itemized deduction, provided the establishment is not availing of the OSD and or does not opt to be taxed at the 8% income tax rate under trade. So dapat po itemized deduction ang ginagamit. Ano po ba yung OSD? No? As a form of review, OSD is a deduction at a maximum rate of 40% of their gross sales or gross receipts. So it will be used as a deduction in lieu of the itemized deduction. This type of deduction shall not be allowed for non-resident aliens engaged in trade or business. An individual who opts to avail of this deduction need not submit the account information return or financial statements. So in this case po, importante po yung ma-determine natin, hindi hindi po kayo pwede mag-avail ng tax incentive kung kayo po ay naka-OSD. Pag kayo po ay naka 8% income tax rate, ganun din po. But we have to consider as a form of review lang po that the 8% income tax rate under train is only available for self-employed individuals, no, whose gross sales or receipts and other non-operating income for the year does not exceed 3 million pesos. So, yan po yung VAT threshold. So, kung kayo po yung mag-exceed dyan, mag-itemize na po kayo. Okay? Right. In any case, we would now, if you have questions with regard to OSD or availment of the 8% income tax rate, although it's not the topic of the webinar, you can post these questions. We will try to answer them at the end of the webinar. No? Okay. Dito naman po tayo sa tinatawag nating Revenue Regulations 19-2020. Ano po ba ito? So ito po ang requirement, no, ng BIR to file an information return on related party transactions, either domestic or foreign. Ano po ba ang related party transaction? Okay. So ang related party transaction po natin, i-define po yan in terms of if you have, paano ko ba sabihin to in Tagalog? Kung kayo po ay may kumpanya, at ang kumpanya nyo po ay may affiliate na isang kumpanya, kung kayo po ay nagtatransact with each other, no, nagbibenta ka dun sa affiliate company mo, it is considered a related party transaction. So in this case, kailangan po nating i-disclose yan. Okay? Itong BIR Form 1709 po, I think we have a copy of that here. Ito po siya. Makikita niyo po dito yung enumeration of the items that you would need to provide in terms of compliance with the provision of this revenue regulation. So kailangan niyo pong isulat yung nature of transaction, related account name, foreign related party, address ng related party, then may tax treaty benefits ba yan, etc. So ayan po siya, sirs and ma'ams, no? Okay. This is not a new requirement. This is not a parang a new development pala. Hindi pala siya new requirement, but it's not a new development. Matagal na po tayong may ganitong provisions. In fact, under yung for accountants that are listening, you are required to already disclose under PAS 24, no? So for the non-accountants, ano po ba yung PAS 24? So under the guidelines, it ensures that an entity's financial statements contain disclosures necessary to draw attention to the possibility that its financial position and profit or loss may have been affected by the existence of related parties and by transactions and outstanding balances with such parties. Okay. Dati po kasi meron na po tayong Revenue Regulation 2-2013, yung transfer pricing guidelines natin. No, so it has a relation to this kasi yung transfer pricing po kasi, ang ibig sabihin nito, katulad po na sinabi ko kanina, may isa kang affiliate na kumpanya, gusto mong magbenta, pwede mong murahan yung benta mo sa kanya para mag-derive siya ng benefit. Or pwede rin namang mahalan niya ang serbisyo niya sa'yo para lumiit yung income mo. Ganon din po yan. Yan po sinasabi natin. And transfer pricing, no, is required para kailangan mong mapakita kung nandun ka ba sa benchmarks na magsasabi na tama yung presyuhan nyo. It has to be arm's length. So kung tama ba yung presyo na binibigay sa'yo ng affiliate mo, kaparehas ba yan ng presyong may ibibigay sa'yo kung ang katransaksyon mo ba ay hindi mo ka-affiliate. So let's say kung ako po may isa akong kapatid na may negosyo, ang benta niya sa akin mura. Pero ang ibig sabihin nun, i-check natin yan kung tama ba yung presyuhan niya is if kung meron related industry, i-check nila kung tama ba or within the same benchmarks yung presyuhan namin dalawa. Or if yung relations namin has an effect on that dun sa pricing naming dalawa. Okay? So yan po yung parang layman's explanation natin sa transfer pricing. Okay, we can discuss that in depth later pag tayo na po, no? After. But in any case, may requirement po kasi tayo dito na mag-disclose, no? So, ano po yung kalapit na let's say disincentive or what we call penalty if in case you do not comply with this requirement. So, as we said, under BIR Form 1709, you are required to disclose yung summary of related party transactions with foreign related parties, domestic related parties, together with the amount of tax withheld, if any. Details of related party transactions per category, other information such as business overview of the ultimate parent company, functional profile of the taxpayer, and pending tax relief application details. Kasi po, kung kayo po ay required mag-file nito, let's say you have related party transactions, hindi ka nag-file, no? Kasi i-attach mo yung BIR Form 1709 sa ITR mo. You can be held liable for penalties provided under Section 250 of the Tax Code. So, ano po ba yung Section 250 ng Tax Code? So, under Section 250 of the Tax Code, there is failure to file certain information returns. So, in this case, it's not, you didn't fail to file your ITR. What you failed to file is, in fact, a required document or disclosure document attached to the said ITR. So, in case of each failure to file an information return, statement, or list, or keep any record or supply any information required by this code or by the commissioner on the date prescribed therefore, unless it is shown that such failure is due to reasonable cause and not to willful neglect, there shall upon notice and demand by the commissioner be paid by the person failing to file, keep, or supply the same, an equivalent amount as provided in the code po muna, no? 1,000 pesos for each failure. Okay? So in this case, may monetary penalty po siya. Okay, may importante po natin ma-consider na ang BIR Form 1709 is an important attachment or a required attachment to the ITR, especially if you have related party transactions with related entities, whether foreign or domestic. Okay, so Revenue Memorandum Circular number 59-2020 na po tayo. So, ano po ba itong Revenue Memorandum Circular number 59-2020? Kasi ng panahon po ng ECQ, alam po natin kung kayo nagnenegosyo sa Pilipinas and you are registered with the BIR, ang resibo niyo po, no? Ang resibo niyo po is registered with the BIR. Hindi po yan piniprint lang basta-basta. May tinatawag po tayong authority to print. Okay? So, it is provided first under Section 237 that all persons subject to internal revenue taxes are required to issue duly registered receipts or commercial invoices for each sale or transfer of merchandise or services amounting to 100 pesos or more. Okay? So, importante po yan na makonsider nyo. Dapat ang resibong ginagamit mo, nakarehistro yan sa BIR. Bakit po natin kailangan yan malaman, no? Kasi may kalapit po na criminal offenses yung pag violate ng invoicing guidelines ng BIR. Kasi under Section 264 of the Tax Code, no? If you use multiple double receipts and invoices or printing of receipts or invoices without authority from the Bureau of Internal Revenue, criminal in nature po yan. Okay? Okay, criminal in nature po yan. Okay. So, in this case po, we would look at yung workaround procedures muna. So, it is provided under RMC 47-2020. It in fact listed kung ano yung mga pwedeng gawin ng taxpayer in terms of invoicing. Kasi they understand during the time ng ECQ, walang office si BIR and there was difficulty moving around. And we understand na may mga nagnegosyo pa rin. No? So kung kayo ay napasukan or nag-expire po ang inyong mga resibo or yung authority nyo nung paggamit ng resibo na yun nung panahon ng ECQ, maaari po kayo makapag-workaround procedures. Ito po yung tinatawag nating workaround procedures, no? So, scan copy of receipt invoice with ATP. So, pwede po yan. Padala niyo po yan dun sa customer. Yan po, scan copy lang. Pwede po yan. Computer-aided receipt invoice in Excel format not covered by an ATP. Tandaan niyo po pwede po yan. Nung panahon na hindi pwedeng nung ECQ po. So pwede po kayo mag-issue na tinatawag natin computer-aided receipt, no? Na not registered. Supplementary receipts, yan din po, CAS or basta, sinasabi lang po dito is you can check 47-2020 and you can, as long as you comply or you fall within the requirements of 47-2020, yan po yung workaround procedures natin. Okay? Pero, you have to understand, ano po yung kalapit na requirement yan afterwards. Under Revenue Memorandum Circular Number 59-2020 naman po, if you used or you applied yung mga temporary measures na ito, no, yung workaround measures na yan, let's say you issued an Excel receipt lang po, no, na walang ATP, you are required, okay, importante po yan, you are required to submit a summary of temporary receipts or invoices within 90 days from the date of lifting of the ECQ and or MECQ. So, yan po yun. So, we're still within the period naman po. So, if you are in fact, if you did issue yung mga temporary receipts or invoices, you can comply with this RMC by submitting a summary of temporary receipts and invoices. Okay? So, also, after ng ECQ, hindi na po pwede gamitin yon temporary measures kasi nagtatrabaho na po ulit ang BIR and you can proceed to apply for an authority to print receipt, ATP. Excuse me. And yung issuance, pwede nyo i-rehistro yung mga resibo nyo sa kanila. Okay, so in this case po, very important po yung summary. We cannot stress that enough. If you fail to comply within the 90-day period po, you fall within the requirements na po ng Section 264. Notwithstanding your compliance with RMC 47-2020. So sabihin mo natin na you made use of these temporary receipts because of RMC 47-2020. Yes, pinapayagan po kayong gumamit. Pero your authority or your use of such temporary receipts is only valid if you comply with the subsequent requirement of Revenue Memorandum Circular Number 59-2020, which is the submission of the summary of the temporary receipts and invoices. So importante po ito. You have to consider this RMC para ma-avoid po natin yung issues with regard to Section 264, no? Which is criminal in nature po. Okay. So, dito na po tayo sa deadlines, extensions for filing and payment. So, in terms of deadlines, extensions for filing and payment, we go by Revenue Regulations 7, 10, 11, and 12, no? Matatandaan po kasi natin, yung panahon ng ECQ, hindi po tayo makapag physically file or manually file ang documents natin, no? Let's say, in fact, the BIR extended the deadlines of filing. So in terms of the revenue regulations po, the reason why they extend na marami pong revenue regulations kasi hindi po na-cover ng isang extension yung buong ECQ period. So they had to issue another revenue regulation pag malapit na po yung extension period. That's why we would be discussing all of them because parehas naman po ang provisions doon. Nag-iiba lang po yung sa actual deadline. Yung date na lang po yung pinagkakaiba. So, let's start. Okay. Kaya makikita niyo po dito, Revenue Regulations number 11-2020, i-discuss natin. But it's the same as the others lang po. No? Parehas lang po ang provision yan. Sabi ko nga po, ang nakakaiba lamang dyan as is yung date ng deadline, kung kailan po kayo dapat mag-file. Okay? So, under the revenue regulations, it extended the statutory deadlines for the submission and or filing of returns, taxes, reports, and other documents. Okay, so for taxpayers that file their tax returns within the original deadline or prior to the extended deadline, ito po yung remedies nyo. Kasi meron po talaga sa atin na sinabi sa BIR, you can file your tax returns earlier, no? So pwede ka mag-file muna na tinatawag nating tentative ITR if you want. So then you can amend it during the period. Okay, so during the period of the extension, no, or the extended deadline, they can amend their tax returns at any time on or before the extended due date. Pwede po yun. So if with additional tax due, pay the same without the corresponding surcharge, interest, and compromise penalty. So let's say meron ka na talagang final ITR. So yung tentative ITR mo, you checked it, you deemed na, oh, ito pala yung babayaran kong taxes, more than what I declare in my tentative ITR. Then you can actually pay without corresponding surcharge, interest, and compromise penalties. Okay, but what if it's the other way around? What if you overpaid sa tentative ITR mo? Nagbayad ka, let's say you pay ₱1 million when in fact you're only due to pay sana 800,000, no, 800,000. So in this case, you either file a tax refund or carry over the overpaid tax as credit against the tax due for the same tax type for the succeeding period. So you have that benefit. As we've said, the revenue regulations na dinidiscuss natin doon kanina, they have the same provisions. All that changed is the deadline, yung actual date wherein the deadline was extended to, right? So we go by Revenue Regulations number 15-2020. This is very interesting, no? Why? Because it extended the deadline of the availment of the tax amnesty on delinquencies to 31 December 2020. So importante po ito na malaman natin ito kasi kung kayo po nagpaplano na mag-avail ng tax amnesty, to-clarify ko lang po, no? The extension applies to tax amnesty on delinquencies. Hindi po ito tax amnesty on estate tax amnesty. Tax amnesty on delinquencies po ito. So ano po ba ang definition ng delinquent account? So para first and foremost, paano po ba kayo mag-fall within the revenue regulations? So it has to be that your assessment has to be a delinquent account with the BIR. So ano po ba yung delinquent account? A delinquent account is defined in the implementing rules as a tax due arising from a BIR audit that has been issued assessment notices, either final assessment notice or final letter of demand, that have become final and executory due to the following instances: failure to pay the tax due on the prescribed due date provided in the FAN FLD, and for which no valid protest, whether a request for reconsideration or reinvestigation has been filed within 30 days from receipt thereof. Failure to file an appeal to the Court of Tax Appeals or an administrative appeal to the Commissioner of Internal Revenue within 30 days from receipt of the decision denying the request for reinvestigation or reconsideration. Failure to file an appeal to the CAR, to the CTA within 30 days from receipt of the decision of the CAR denying the taxpayer's administrative appeal to the decision on disputed assessment, or FDDA. So in this case po, if any of your assessments fall within that definition, then it's considered a delinquent account and you can avail of the tax amnesty. So in this case, what are the requirements for availment? So concerned BIR office receiving the request for certificate of delinquencies, tax liabilities. So you would have to request the RDO wherein you are registered for a certificate of delinquencies or tax liabilities. So it shall be issued to you within 3 working days from date of request. So if certificate cannot be issued, the said BIR office must state in writing the legal and factual basis for its denial. So concerned RDO, LTD, LTCED to endorse the duly accomplished tax amnesty return. I do think we have a copy of that right here. So this is a tax amnesty return on delinquencies. So you can see here delinquent accounts and assessments which have become final and executory, tax cases subject of final executory judgment by the courts, because under the earlier revenue regulations implementing the tax amnesty, it has these categories po, or accounts that can be amnestied. So in this case, and an acceptance payment form. So this is an acceptance payment form. So makita niyo po yan. Yan. Sorry. No, 1701, iba pala yun. Okay. So in this case, filing of the required documents after payment must not be beyond the new availment period. So it was extended, yes. But the deadline is strict, so it has to be the amnesty application and the payment should be made before December 31st, on or before December 31st, in order for you to be able to avail of the amnesty. Okay, so now we go by deadlines, extensions for filing and payment. As we've said earlier, in implementing the Bayanihan to Hilas 1 Act, Revenue Regulation 7, 10, 11, and 12. We discussed them all together. And these are the circulars naman po na how do I put it in Tagalog? Na nagpapakita or nagsasabi talaga, na-explain kung ano yung mga extensions na yun, kailan talaga kailangan bayaran. Also, makikita po natin dito yung tax amnesty on delinquencies na kailan po yung deadlines natin. Kasi meron po tayong tinatawag na extension na deadline ng withdrawal ng protests para maging delinquent yung account. Nandiyan din po yan. So, mag-start po tayo sa Revenue Memorandum Circular number 11-2020. Ano po ba ito? So, Revenue Memorandum Circular number 11-2020 clarified certain issues on tax amnesty on delinquencies, thereby amending and supplementing Revenue Memorandum Circular 57-2019. So, nandiyan po siya. So, consider delinquent account qualified for tax amnesty. We do have Ms. Shadi raised their hands. Okay. If you do have questions and you don't want to, just so we can proceed, just want to address this. If you have questions, please feel free to type them in. We would try to address them in the Zoom webinar. And I know for a fact that we're appearing live in Facebook. So if you have questions over Facebook, kindly type them in. We do have moderators in the Facebook Live reading your comments and actually presenting these questions to our panelists. So feel free. If you don't want to reserve your questions till after the webinar, please do post them now. It's fine. The panelists would be glad to address these questions of yours, no? So, importante po dito kasi na may deadline po dito, timely protested or disputed but was withdrawn at any time on or before April 23, 2020. So, sinasabi po dito is if you have a pending protest or a petition before the courts, before the CTA, you must withdraw them before April 20, 2020 in order for it to be considered a delinquent account. Therefore, you can avail of the amnesty. Okay. So medyo mabilis po tayo dito kasi mostly reiterations lang po ito ng mga nabanggit natin nung mga nauna. So it may touch on a revenue regulation we already discussed, but specifically on the dates, it emphasizes on the dates, either an extension or the deadline. Yan po. So ito po, this is very important that you have to consider. In fact, our firm devoted full day of research on this matter, specifically on the matter of the lifting of the state of national emergency. Why is this important? Siguro po kailangan pa natin bigyan ng pagtuunan ng pansin itong memorandum circular na ito. Matatandaan po kasi natin dito na noong panahon ng ECQ, hindi po kasi makapag-issue ng assessment notices si BIR. It's either hindi po sila makapag-issue or nahihirapan po silang mag-issue. So in this case, po, starting March 16 until the lifting of the state of national emergency, and plus 60 days, no? And for 60 days thereafter, the statute of limitations under section 203 and 222 of the tax code parang well, suspended, no? So dapat din po during the period there is already a suspension or issuance and service of assessment notices, warrants, enforcement and or collection of deficiency taxes. Okay. The reason why there is a confusion po, no, specifically with regard to this matter, is kailan po ba natin i-recon yung 60 days? Kasi po, tandaan po natin na the BIR only has 3 years to assess, right? 3-year period to assess you for deficiency taxes. And that 3-year period is reckoned from the date of the filing of the return or the amended return. So let's say you filed in 2017 pala, sorry, 2017 June. And it is supposed to prescribe June of 2020, 3-year period. So in this case po, with the suspension of the running of the statute of limitations, you will not be able to claim the defense of prescription of the right to assess. Yan po yung implication nitong Revenue Memorandum Circular number 34-2020. The only time na pwede natin gawin dito is during that 60-day period, understanding po namin sa interpretation ito, during the 60-day period, the BIR should issue the corresponding assessment notices, warrants, enforcements, or collection of deficiency taxes during the 60-day period. If your assessment is due to prescribe within the 60-day period, the BIR can still issue you assessment notices, warrants, enforcement, or collection of deficiency taxes. But on the 61st day, right, on the 61st day, the BIR can no longer come after you for the deficiency taxes on the assessment that was already prescribed. Real defense po kasi yan. Yan po yung pinaka-importante ditong context na makuha natin sa Revenue Memorandum Circular number 34-2020. Number one, it's highly unfair kasi ang prescription po dapat yan, ano yan, jurisdictional yan eh. Sa batas po yan. Kung hindi natin ma-avail yan, yan yung pinakamagandang defense na makukuha ng taxpayer. So in this case po, the BIR is given 60 days. So dapat, during that 60 days, alam nila kung sino dapat i-issuean nila. But if they fail to do so, on the 61st day, dapat, kung nag-prescribe na yung sa'yo during the suspension, dapat on the 61st day, mag-prescribe na siya. Ganon. Yung definition po natin dito, no? Kasi wala naman pong amendment sa 3-year period. So dapat ganun pa rin po siya. Okay? So if you have questions specific po sa case nyo, with regard to, let's say, if you feel that you are in fact, or you have an assessment or a taxable year that's still open, that would greatly benefit from, let's say, prescription, you can actually ask the panelists later how we would be able to address it for you. But in this case, the 3-year period, if you fall within the suspension, plus 60 days, in the 60-day period, they can actually issue your assessment notices. Failing to do so, we can consider the right of the BIR to assess you as prescribed. Ang problem lang dito, sirs and ma'ams, is determination of when would be the reckoning of the 60 days. Until now, up in the air pa rin po yan kasi even our office is split on the opinion of when to reckon it. But suffice it to say, if it prescribes, if your assessment prescribes within the period of the suspension of the statute of limitations, the BIR would be given 60 days after its lifting to assess you. If failing to do so, on the 61st day, you would be that right to assess would prescribe. Okay. So sa RMC naman po 39-2020, ine-extend lang po yung period to file yung certain taxes for additional period of 15 days. So yan lang naman po yan. Sinasabi natin dito, katulad kanina, 39-2020 can be discussed along with RR 7-2020 because along with the requirements ng Revenue Regulation 7-2020, yung RMC naman po, sinasabi dito na kung ikaw ay may filing na mag-fall due, no? Na mag-fall due within the period of the ECQ or the extended due dates, meron kang mabibigyan ka na 30 days. So filing of position paper to notice of informal conference, up to other similar letters and correspondences with due dates, 30 days from the date of lifting of the period of emergency. So suspension of running limitations, yan yung katulad sinabi natin kanina sa earlier 34-2020, 60 days after the lifting of the order of the state of emergency. Pero yan nga po ang hindi natin maintindihan. Na-lift na po ba yung order of state of emergency? Kasi currently, Metro Manila is still currently under GCQ. So, do we consider ECQ as the state of emergency, or do we consider GCQ as falling within the definition of the state of emergency? That we leave up to some other taxpayer who would want to question that. Pero ang opinion po namin, sabi ko nga po, medyo hindi rin po kami sure, no, when to recon the lifting of this order of the state of emergency. Suffice it to say, ang rule of thumb po natin dapat, our RMC number 34-2020, the BIR was the basis of the BIR's issuance is that they were precluded from, or they were prohibited, or there was great difficulty on the part of the BIR to issue their assessment notices, collections, etc. during the period of the ECQ. Kaya nila kailangan i-suspend yung statute of limitations. Kung ngayon po, nag-i-issue na sila ng mga ganong issuances or ng mga collections, then it should follow that the statute of limitation or the 60-day period should already be running. Yan po yung theory natin. So in this case, although there's no definite answer to the question pa, we can explore it further po, siguro, in subsequent, in test cases, subsequently, baka meron pong lalabas na test case as to the when to recon the 60-day period. So dito tayo ngayon sa Revenue Memorandum Circular number 41-2020. So extends the time for filing of application for new ATPs, or authority to print receipts, invoices of taxpayers with expiring principal and supplementary receipts, invoices, and extends the use of expired principal and supplementary receipts or invoices. So ito po yung katulad ng pinag-usapan natin earlier on the workarounds po, no? Ayan siya. So where the expiration dates of the said receipts fall within the period of the ECQ, filing of application for new ATP is extended until May 13 or of 30 days after the lifting of the ECQ if extended. So ngayon po dapat June 30 yung deadline nito. So there were no penalties po if you fail to renew your ATP upon expiration, as long as you renew it, okay, yung within 30 calendar days after lifting of the ECQ. Okay. So itong RMC number 52-2020 naman po, no? So it allowed the temporary filing of the withdrawal of protest via email for purposes of tax amnesty. Kasi nagbigay po sila ng deadline na April 23. So it has to be done that way. So ang problem lang was during that period, there was ECQ, the government, the BIR was not in their offices. And of course, there's great difficulty on the part of the taxpayer to submit physical documents to the BIR. So in this case, they can submit these documents via email, right? In compliance with RMC 52-2020. So RMC 61-2020, it further extended the deadline. So this would be rendered moot na po because As to the extension kanina, we were able to determine already that the extension has been the deadline has been extended until 31 December 2020. So you can actually file your amnesty applications until then. So guidelines for existing procedures. So we will be discussing, this will be the last topic of discussion for this afternoon. So Revenue Regulations number 14-2020 amended the pertinent provisions of cash conversions of unutilized credit certificates under Revenue Regulation 5-2020. So we'll go one by one. RMC 37-2020, filing of tax returns and payment of taxes before the extended deadline, so yung effects nun. RMC 42-2020, guidelines in the filing and payment of income tax returns for taxable year 2019. Kasi as you know, the deadline for filing fell within the ECQ. Okay, so RMC 56-2020, payment of internal revenue taxes until June 14, 2020. So let's go by one. Ang pinaka-importante po dito is yung Revenue Regulation 14-2020. Ano po ba ito? Okay, so we understand that taxpayers, right, if ever they overpay their taxes, would normally get a tax credit certificate. So in this case po, the Revenue Regulations 14-2020. So if you were not able to utilize your TCC for more than 1 year at any given interval of time, it shall be converted to cash automatically. Importante po kaya dito kasi ang kailangan po natin makuha yung idea kung bakit in-issue itong Revenue Regulation 14-2020. In-issue po ito kasi para ma-capture ng gobyerno or in particular ng Bureau of Finance kung magkano talaga ang nakukuhang cash, pera, as in cash talaga ng gobyerno. So in this case, kasi alam po natin na meron pong tax credit certificates ng mga taxpayers at hindi po nakaka-capture ng gobyerno kung magkano talaga yung actual collection for the year. Kasi syempre, application ng tax credit certificate, etc. So in this case, by converting yung unutilized TCCs, no, malalaman nila kung magkano talaga yung pumapasok na pera sa gobyerno. So maka-quantify nila kung magkano yung nag-overpayment at magkano talaga yung kailangan na collection lang nila for the year. Kasi if, as you can see, sinasabi nga natin may mga overpayment tayo. So that is not the actual tax collection because the government does not have, is not entitled to the excess collected taxes. Kaya nga po nag-i-issue sila ng tax credit certificates. So in this case, ano po ba yung requirements with prior written notice by the BIR? Of course, subject to the availability of funds, no? And in accordance with procedural requirements which will be issued by the BIR. Maganda po ito, yung revenue regulation na ito. Let's just wait for the issuance, subsequent issuance clarifying revenue regulations. But nevertheless, the premise behind all of this is to capture the actual cash collection of government in a particular year, no? So malalaman nila talaga kung magkano yung nakukuha nilang pera. Hindi lang yung collection as is, but the actual tax collection. Kung magkano yung talagang entitled sila na makuha. Okay. So revenue regulations, okay, 11-2020. This is okay. Revenue Memorandum Circular 37-2020. Taxpayers who filed tax returns within the original deadlines, as we said, or prior to the extended deadlines, can amend their tax returns at any time on or before the extended due date. So, reiteration lang po ito no earlier na pinag-usapan natin na pag ikaw ay na-overpayment, okay, pwede kang mag-apply ng, pwede mo siyang i-apply dun sa tax due for the same tax type in succeeding periods returns. Or if meron kang deficiency, as long as you fall within the deadline, you can actually file an amendment and pay the deficiency tax without corresponding penalties. Okay? So, if you don't have, ito pa pala, meron sa RMC na ito na nagsasabi kasi na kung ikaw ay EFPS filer, kasi they were encouraging EFPS payment ng time ng ECQ eh. But there's a specific, how do I put this, group of taxpayers that were not covered by the January 2018 version, no? So sorry, by the EFPS. So hindi siya available in particular return, yung 1701. So they have to file manually and then pay. You can either pay manually or online payment. So ano po ba yung manual payment? So importante po ito ma-consider natin kasi meron pong jurisdictional requirements ito at may corresponding penalties for erroneous remittances. So manual payment as defined under RMC 16-2020 is through the authorized agent bank within the territorial jurisdiction of the RDO where the taxpayer is registered. Or if the area has no AAB, it shall be paid with the concerned revenue collection officer under the jurisdiction of the RDO using MRCOS facility. So online payments, on the other hand, is through, of course, as you know, GCash, Land Bank of the Philippines, Link.biz portal, DBP Tax Online, Union Bank online web and mobile payment facility. For taxpayers who have accounts with Union Bank and PesoNet, you can pay through Land Bank of the Philippines, Link.biz portal. No? So it's important, no, that you comply with these requirements because, as we've said, failure to follow through kung saan ka dapat magbabayad can merit a levy or a surcharge for wrong district payment. Okay. So Revenue Memorandum Circular 42-2020 so provides the guidelines in the filing and payment of income tax returns for taxable year 2019. So it's just parang a reiteration of what you're supposed to be doing, considering that there was in fact difficulty. So they just told the taxpayers, anong forms gagamitin mo, saan ka pwede magbayad. Yan po yun. So for the payment online, as we said, they could make use of the guidelines provided under Revenue Memorandum Circular 16-2020. So RMC 56-2020. So remember when we discussed yung filing ng returns on a specific RDO, specific AAB, this is where you have to pay. This clarified that RMC. So they understand that there was in fact difficulty during the time of the ECQ to move around. So let's say my business is in Ortigas, I do live in Las Piñas. If I were to follow in the ordinary course of business, manual filing and payment, I would have to go to the RDO in Pasig and pay in an authorized agent bank in Pasig in order for me to comply with the requirements of manual filing and payment. In this case, the filing of and the payment of tax returns was clarified. So concerned taxpayers may file tax return and pay the tax at the nearest AABs, notwithstanding RDO of jurisdiction. File and pay the same to the concerned RCO of the nearest RDO, even in areas where there are AAB. So they practically did away with the requirement that you would have to pay within the authorized agent bank registered in your registered with your RDO. So this is important because under the rules, wrong venue filing or filing of tax returns at a different revenue district office than where they are registered is subject to a penalty of 1,000 per return. So yeah, it's 1,000 per return and a 25% surcharge of the tax due to be paid out of district surcharge. Okay, as we understand, medyo mura lang yung 1,000 if you are in fact a large taxpayer. 1,000 may be very minimal, but you have to understand that 25% surcharge can be substantial. No? So it is levied on the tax due. So if you're paying maybe 100 million, then you would be levied an out-of-district payment of 25% if this RMC did not exist. Okay, so in the ordinary course of business, since the whole issue of emergence, if the whole issue of the ECQ has been lifted, as a word of caution, if you are not sure which RDO you are registered, please clarify. That's number one. Number two, kindly check the list of authorized agent banks, considering that if you pay out of district, as we've said, you would have to pay a 25% surcharge, okay? Also, if you are an EFPS filer, right, this is also important. If you are an EFPS filer and you are also mandated to file your returns and pay through the EFPS facility, and you filed manually and then you paid manually, considering that there were problems with the EFPS facility, you would be levied a 25% surcharge for wrong district payment. Okay, so as a in order to comply, right, in order to do away, if you're an EFPS filer and payer, to do away with the 25% surcharge, it is safe to do is to secure a trouble ticket. Let's say if you're not able to file because there are errors within the system of the within the EFPS system, you call the BIR hotline and then request for a trouble ticket. That is your proof that in fact the system had errors at the time that you were supposed to make your payment, and then you would be allowed to pay out of this. You would be allowed to pay in the RDO of registration. Okay. So that's it. Ladies and gentlemen, thank you for being with us for around 2 hours and 30 minutes. Thank you for giving us your time. Our panelists will be available to respond to your questions, right? So I would be, for those within the webinar, within the Zoom webinar, I would be unmuting the attendees. So you would now be allowed to talk. So if you have questions, concerns, you may raise them with our panelists, and they would be more than glad to address these questions of yours, right? So if I may request the panelists to introduce themselves again for the benefit of the attendees. Attorney Oliver, Ms. Myra.
Hi, good afternoon, everyone. Thank you.
All right. So, attendees, do you have any questions for our panelists? It may not be related to the subjects and webinar, but if you have, let's say, questions related to your business, which has a slight relation to the webinar, please feel free to ask questions. Same goes for those who are joining us through FB Live.
Actually, there was already one question. Ang question niya is it possible for 2 branches to be registered in one RDO? So our answer there is that yes, it is possible. In fact, yung last 3 digits ng TIN, yun yung assigned for each branch to differentiate it from each other.
Okay. And another question was raised, no? Tuwing kailan kailangan mag-change ng RDO? So nagpapalit lamang po ng RDO pag lumipat ng address yung kumpanya na sakop ng ibang RDO. So that's the only time that you would actually need to switch RDOs pag ilipat ka ng jurisdiction. Pero as a word of caution po, pag lilipat kayo ng RDO, you would be subject to closure proceedings po within that RDO. And then it's either ano po sila ng, let's say, you have a pending assessment doon sa RDO na yun, dadalhin po nila yun sa panibagong RDO. Any other questions? Nasa inyo naman po ang aming email address, no? So if you have any more questions and ayaw nyo lang po siguro, hindi pa kayo nakapag-compose ng inyong questions ngayong hapon, maaari nyo pong ipadala yung questions nyo sa aming email. We would try our best to respond to you very quickly. And then ma-address po namin itong mga katanungan nyo. yun naman po ang aming initiative, no, with the webinar. So thank you again for the people who spent their afternoons with us. I would like to speak on behalf of the panelists as well for Attorney Oliver. Attorney Oliver, there's a question here. I'll read it out loud for the benefit of the other attendees. Is a tax clearance can a tax clearance be used as evidence that you are already deemed clear of your tax liability in a certain period of time? Hello? Hello, Attorney Oliver? Hello?
Hello. Yes.
Yes. There was a question whether or not a tax clearance can be used as evidence that you have already deemed clear, or that you are already deemed clear of your tax liability in a certain period of time.
It may be used as an evidence that you're cleared of a particular period, especially if the tax clearance specifies the period, no? Although it does not necessarily give you a blanket clearance for all taxable periods. So as long as the tax period is open, depending on the circumstances, you may still be audited by the BIR.
So if it's clear, just to summarize yung reply, it does not preclude the BIR from their audit po, no? It is used as evidence that you are cleared, but it will not preclude the BIR from auditing your company.
Yeah, kasi sometimes may mga tax depends kasi on the purpose that tax clearance was issued. Iba-iba naman yan eh. Like for example, you may be issued a tax clearance if there is a even if there's a pending tax assessment, but it is appealed through the courts, the BIR may still issue a tax clearance for you for the taxable year, but that is without prejudice to the outcome of the case.
Right? Any other questions? Okay, so should there be no other questions po, no? Please just email us. We will try to respond. And again, thank you very much. We hope that you learned something from the webinar. We would be uploading the recorded video of our webinar in YouTube and in Facebook, just so you would be able to refresh yourselves of what we discussed this afternoon. So thank you very much. Thank you very much po. Maraming salamat. Magandang hapon sa inyong lahat.